Okay, good afternoon, and happy Monday, and welcome to our Power Hour. First, I would like to introduce our speaker for this particular event. Her name is Stratford Tiger, Bank of America Senior Vice President. She is a private client advisor, and we will be talking about Let's Talk About It, a conversation with mom and dad on trust and estate planning. On behalf of the North Carolina Bar Association, the Paralegal Division, welcome.
Well, let me say thank you for sure. I really appreciate being here. And, this is a topic, whether you're talking with your parents or with really any other friend or relative, that I tend to define to be very timely and very, very much needed when I was in private practice, and certainly when I've come back to the bank. So let me just go ahead and get started, because the first part of this really is just kind of setting the stage around why we need to have this conversation. And so one of the things, that's been happening over the last few decades and is projected to go on, certainly for the foreseeable future, is really a change in the demographics in the United States. And so you can see, they call it from pyramid to pillar, what the change has been. And really it's this shift towards having a much older population. And in fact, in 2030, the early 2030s, that is going to be the first time in the United States where we have more individuals over the age of 60 than we have individuals under the age of 18. And so you're going to see that ripple through in terms of the need for caregiving, but not as many individuals to be there as caregivers, in addition to the big drawdown on Social Security, without as many people paying into the Social Security fund or the tax pools. And so again, just really a lot going on around demographics. The other thing, and again, we all know this, you tend to see an increase of Alzheimer's and dementia by age group. And so with the expansion of an older population, we are going to begin to see a significant increase in the number of individuals that have a cognitive disability. We also tend to see that Alzheimer's and dementia is almost twice as prevalent in women. And so as we have this greatest generation and really the boomers kind of hitting that age group, we also tend to see that men may have been the primary in terms of handling the financial affairs and the household. And now you've got women outliving men, but those women have twice the risk of, again, having a cognitive impairment. And so just things to be aware of as you begin to plan for this age group. One of the things that we also see is more hospitalizations, again, by age group. The older an individual, the more likely they are to have an emergency room visit, either for an illness or more often for a fall or some type of accident. And so again, making sure that we've got the right individuals in place to assist that person should they need a sudden emergency type assistance under a medical healthcare power of attorney. And then the last thing that I used to run into in private practice, and I still run into at the bank, is we see significant increases in fraud as an individual ages. Part of it is they may not be as familiar with technology. They may be living on their own. They may be too embarrassed to ask for help. And sometimes they're just starved for attention. And so when a scammer has the ability to make a connection with them, they can usually significantly defraud them before it's caught. And once the frauds happen, it's very difficult to get those funds back. And then there's also a lot of shame and frustration that, they just really struggle to get over. So with that in mind, everything that I've just said, I really doubt is news to anybody on this call. But I do try and put it into the context of why it's important to have this conversation, preferably before you get into a crisis. So the next thing is knowing your audience. And my first question that I usually have with individuals who ask my advice about this is, who wants to talk about their death or giving up control of their affairs? And that's true for any of us on the call. Chances are most people would say those are not two subjects that I want to talk about, particularly if it pertains to me. Well, that means going into this conversation with either your parents, your in-laws, other relatives, friends and neighbors who might be older, they probably don't want to talk about this. They're probably going to be very defensive. And so you've got to kind of have that mindset as you move forward into the discussion. Now, I pulled some survey data. I had done this presentation during COVID and then went back and refreshed the data. It hasn't changed much. In fact, it's gotten worse. Right now, 2 out of 3 Americans do not have any type of estate planning document. So that's 66% of the population over the age of 18 do not have estate planning. That means 2 out of 3 of us on the call may not have estate planning. More than 40% of that group will not get a will until they feel their life is in danger or they have a major medical event. The problem with that, that's probably the worst time to try and get your affairs in order. They're probably already under duress. They're probably in a panic, and they may not be thinking through all of the decisions the same way they would if they could do this at a time when they're not stressed. And then lastly, 25% say, you know, there's really nothing that would motivate me to get my affairs in order. And so you've always got those holdouts where when the crisis comes, you're going to have to rely on other alternatives in order to try and make sure that they're cared for. So the first number up here where it says 35% of American adults say they have personally experienced a family conflict as a result of not having an estate plan in place. Let me tell you, having been in private practice, I can tell you that number is low. I think just about everybody has got some sort of horror story of how assets went to people they shouldn't have gone to, how somebody inadvertently got cut out because of a transfer on death or payable on death designation, how somebody didn't tell them about all the debt they had, or maybe all the assets had already been transferred and there was nothing to pay for the funeral. You know, 35% based on my personal experience when I was in private practice is probably low. Now, the other thing that I tended to see was someone would be handling the estate administration for a family member, and they would come back and say, I never want to do this to my family. I never want to do it to my kids. So let me do my estate planning. And there was another survey that Bank of America Merrill had done back in 2018 that said, you know, 52% of people surveyed said that it was irresponsible to die without having your affairs in order. Tack on another 22% that said if it's not irresponsible, it's inconsiderate, and another 14% that said it was ignorant. And basically, you've got about 88% or more that felt like it's really something that we should do in order to be responsible adults. Make sure that should something happen, things are going to be handled in an organized manner. So how do you have the talk? I'll tell you the tricks that I've seen, or the ones that have worked best. Number one is to lead by example. So if you're one of the 66% that either needs to complete your estate documents or maybe revise them, that is the easiest way to start the conversation. Because if you're sharing your own experience with that person who might be defensive, maybe it's an older relative or an older friend or family member, And you can say, you know what, I just met with my attorney and I feel so much better having things organized. I don't have to worry about it. Have you done yours? That's a great way to start the conversation without immediately putting someone on the defense. The second thing is make sure that it's a discussion and not a lecture. I can't tell you how many times I sat in a conference room with a family and the adult child or children are just really kind of taking mom or dad or the aunt and uncle to task and telling them how they needed to do it. Just keep in mind, inheritance is a privilege and not a right. You know, it's not an inheritance until they've passed. And so while they are their assets, they have the right to decide what they're going to do with them, even if that means to give them away. And so, you know, part of the other thing you have to keep in mind that when you're asking someone to give up control, that can be very humiliating to them, particularly if they're the ones that had always been in control before. The other thing I would highly recommend is if time is on your side and you have the ability to kind of ease into the conversation and have it over a period of time, that is certainly a better way to approach it, because there are a lot of things that need to be considered. And sometimes I'll have that one individual who has read something or seen a situation that didn't go well, and they now feel like this is on the to-do list. You need to get this done and you need to do it now. You know, you have to keep in mind that just because it's a priority for you, it may not be a priority for them, particularly if they've just suddenly been blindsided. And so again, trying to ease into the conversation usually has a better result. I would highly recommend that you avoid times that are already distressing. Where I used to see this happen is somebody would have an unexpected accident. Maybe it was a fall, maybe it was some other thing or an unexpected illness. And all of a sudden, in the middle of that crisis, somebody wants to start talking about your estate planning. Well, they've already got a whole lot going on. Maybe they're just trying to get through the initial trauma. Maybe they're looking at having to now go to rehab for a couple of weeks. Maybe they're going to have in-home care for a couple of months. You know, that's a very stressful time period. You don't need to pile everything on right when they're in the middle of a medical event. And so again, you know, sometimes there is a need to do something quickly, but most often there is time that you can wait and let things settle down and then do that. Leveraging opportunities. I will say I have seen that the medical professionals are being much more proactive about having the conversations, at least around healthcare powers of attorney, advanced directives, most forms. If somebody else plants that seed and makes a recommendation, that is a great time to kind of leverage that opportunity to say, you know, I heard your doctor asking about your documents. Do you think we need to revisit them? Do we need to review them? Maybe we need to get them in place. And so again, now you're not the bad guy putting somebody on the defense. You're just merely following up on what another professional has advised. The other thing I would say is privacy should be a priority. Again, when you're talking about somebody's financials and somebody's wishes for how they wish to be treated at end of life, you know, those are private matters that they may not be comfortable sharing with everybody. And so the individuals that for some reason decide to bring this up over the holiday meal in front of everybody, in front of multiple generations, maybe in-laws, maybe significant others, you know, that's the wrong time. That is going to shut somebody down very quickly. Usually it's easier to have one or two family members that someone feels comfortable with, where they feel like they can share that information, even if it's kept in confidence until such time that it needs to be used. And then the last thing that I would say is do not berate, belittle, or threaten somebody during this process. And that might come across harsh, but I will tell you that in 12 years of private practice and the rest of the time in banking, I'm not really sure I've ever met a normal family that didn't have some type of dynamics, my own included. And so sometimes it is very difficult to get over things that may have happened in the past. Particularly, I see a lot of situations where maybe you have a child who has become estranged for multiple years, and then suddenly they are jerked back into a relationship that they chose to leave and are now being asked to be a caregiver. That may not be a positive situation for either side. And if that's the case, that is okay. You know, that's the time to engage a professional advisor or some other neutral to kind of serve in that role and have a dialogue that may be too painful for them to have, you know, again, with either side. So let's just talk about the basics of estate planning. And I'm certain that most people on the call already know what the primary documents are. The ones that we generally recommend are certainly a will, particularly if anybody owns real estate and if anybody needs to name a guardian for a minor or some other dependent. You really do need to have a will. Now, for most people, a trust, you may not need a trust if privacy is a priority. You know, certainly using a trust can be important. If you own real estates in multiple states and you don't want to do ancillary administrations, you may want to have a trust. If you have very specific distribution schemes for beneficiaries, if you have charitable intent, you know, again, you may want to use trust. If you have special needs situations or individuals that are dependent on government benefits, again, you may want to use a trust. And then the last financial document would be the durable general power of attorney. And again, this can be as broad or as narrow as the individual needs it to be, but it basically allows for someone to handle all of the legal and financial affairs. For the 3 health documents, always recommend a healthcare power of attorney. Now, the best thing about this is every state has a statute that will provide should a healthcare power of attorney not exist. Contrary to a durable power of attorney, if you do not have those documents in place, your only alternative may be a guardianship. And so at least with a healthcare power of attorney, there is statutory law in each state that will allow individuals to step up in a named order. An advance directive or a living will. Sometimes this goes by different names in different states, but basically it's the same thing. If somebody feels very, very strongly about how they are to be treated at end of life, when to a high degree of medical certainty, the individual is not expected to survive, that is where these wishes are stated. And so your healthcare power of attorney will then dovetail into this advance directive. And then lastly is the HIPAA release. And the reason that I kind of highlighted this red, all of the other documents are state documents, but HIPAA is a federal law. And even though a durable general financial power of attorney and a healthcare power of attorney might have a sentence in there or a paragraph about a HIPAA release, it is usually not robust enough, nor is it the standard 3-page HIPAA form under federal law that will give your agents the full authority to make a decision based on medical records. And so we always recommend having that extra HIPAA release just to make sure that if somebody is having to make a major medical decision, they've got all of the information available to them. So this little grid I put together when I used to talk with clients because I would have everybody come tell me, oh, I can talk on behalf of my parents. I'm named as their executor. That is great, but unfortunately that does not come into effect until after they have passed away. And so I used to try and explain to people the most critical documents to me are the ones that are in effect while you're alive, and not necessarily the ones that go into effect after you die. because once you are deceased, at least you're out of the picture. And so you want to make sure that while you're alive and people are having to act on your behalf, you definitely have your affairs in order. So the first one up here is the healthcare power of attorney. The reason it goes across the little red line, which is supposed to be the moment of your death, is because most states allow an agent under a healthcare power of attorney to handle your final affairs. And so we used to get called in either to mediate or to litigate around who gets to make the burial decisions, who gets control of the body. And so again, if you've got a healthcare power of attorney in place, you can go ahead and avoid that potential conflict within family. Durable financial power of attorney. This is in effect either immediately or springing on some sort of criteria up until the moment that you die. I always counseled individuals, please stop using the power of attorney after someone passes away because it is no longer in effect. Account ownership and access. Sometimes individuals use this as a way to kind of not be as formal as a power of attorney, but you have to be very careful. Depending on the financial institution where someone banks, you may be able to add a signer that does not necessarily make them a joint owner. And the reason that that is critical is if you do it incorrectly, it can either facilitate fraud or it can be deemed gifting, which could later impact the individual's eligibility for benefits. And so you need to really be aware of what role you're setting up if you're going to change account titling. The one under that is guardianship. And again, even though I spent 12 years working on guardianships, either being appointed by the court as guardian of the estate or representing either the wards or the respondents, if you have the ability to avoid a guardianship, I highly recommend it, only because it is incredibly expensive, it is very restrictive, and it can also be very embarrassing and frustrating for the ward as well as for the family. And so again, if you have the ability to avoid a guardianship by having the other documents in place, highly recommend doing that. The other side that come into effect under death are transfer on death, payable on death, and beneficiary designations. All of those items operate under contract law. And you have to be very, very careful when you are using those because they can frustrate the estate plan. And most people don't realize that until after it has happened, and then you have to litigate. And again, you've got contract law separate from probate law. Last will and testament comes into play, again, from the moment of death on. And then at the bottom are trusts. And again, I've got trusts all the way across because they can come into existence during lifetime. They can be testamentary trusts that spring into place at death, and then they can carry on far beyond the moment of death. And so again, knowing whether or not a trust is and the best way in which to use is a conversation with the estate planning professional. So the key steps in terms of an action plan going forward, first off, sometimes it can be from friends that have had experiences, but always if you can find a financial, a legal, or a medical professional to have that conversation, take that time. Individual, what does each document do? What are the powers that you're giving away? And what does live and that may then control when you're either incompetent, incapacitated, or deceased? Getting the essential documents in place is critical. The sooner that you have them in place, and if they've been drafted correctly, you hopefully will not need to go back and continue to change those. And again, it's almost like a relief to know that you've gotten them done and we don't have to worry, particularly if you have the ability to do it before you end up in a crisis. Reviewing your existing accounts and assets, again, very, very critical, particularly if you have got beneficiary designations on there. You need to always revisit to make sure that they're still current, because certain things, you know, can be unexpected. Maybe you have a spouse from a former marriage on there. It's a contract. It's, you know, again, depending on the state law, depending on the actual document, you may or may not be able to prevent them from receiving something if they're listed on a beneficiary, even if that wasn't intended. You've got to look at ownership structure and titling to make sure that. So if you've got a revocable trust or you've got assets that you're trying to put into a trust for protection, have they been titled that way? Are things still held as joint with rights of survivorship? That means it goes immediately at death to the other person. Is it tenants in common? Now you're going to be splitting an asset that's going to be controlled by different individuals. And so understand titled and whether or not they're still up. I have seen a lot of TOD, POD, and beneficiary designations get put onto accounts at the recommendation of financial advisors without going back and checking with the estate attorney to make sure that you haven't completely disrupted the estate plan. And again, sometimes we catch it after the fact and then it's too late to change. And then the last thing is, you know, there's a recommendation to at least review your plans every 5 years. It's more important to review them when you have major life events. You know, maybe there has been the sale of a large asset and now you've got all of those proceeds in cash, where if your will said, give my house to my son and my checking account to my daughter, is that still the way it should go? Because you may now be inadvertently disinheriting one of your beneficiaries. Are there significant changes in wealth? You know, maybe now we have a taxable estate and we've got to accommodate for that. Maybe there's been a change in an appointee. I used to have a lot of people come in and the parents were named and now the parents are in their 80s. And so, or maybe now your kids who were young minors when you did your documents are now young adults. And so do you need to change? Maybe an appointee has had a health issue and can no longer serve. So making sure you've still got the right individuals. And then lastly, you know, tax laws are really one of the primary things most likely to change. And just trying to stay on top of that in case it's an estate that's going to be impacted. The last thing that I put on here is kind of really more of a warning, which is designations are not a substitute for a trust. This goes back to the beneficiary TOD and POD designations. You know, there's a lot of information out there about being careful when you are looking at trying to leverage these techniques to, quote, avoid probate. Everybody talks about wanting to avoid probate to save on fees. You know, I can speak certainly for North Carolina and South Carolina, and you've got to have a multi-million-dollar estate to hit the roughly $6,000 fee limit, which is capped, you know, and that's all it's going to be. There's a lot of protections, particularly around creditors, where it's actually better to go through probate. Certainly if there's real estate involved, you're not going to have a choice if you want to have clear title to that property. And so again, anybody who's telling you to try these techniques in order to avoid probate, you really have to understand what you're doing. Most often I see tax issues created, or I see people that are now rendered ineligible for benefits. And if you were going to be dependent on benefits to pay for long-term care, you've got a huge issue at that point. I think that is the end of my deck, and I wanted to leave some time, really to answer questions. Put everybody to sleep?
So I have a question.
Sure.
Okay, so I had put this in the chat about the POD and the TOD because my estate attorney actually recommended to my husband and I, we did our wills last year, to do the TOD and the POD. But my other question with that is when you do that, if you don't do the TOD or you don't have the POD, how difficult is it to take care of the accounts, the banks, the vehicles, et cetera, if you don't have that? Because my thought was that if you have the death certificate, it shouldn't cause too much of a problem.
Well, so I'll put it to you this way. If you have a death certificate and you probate the will in order to start the clock to cut off creditors, you're going to get a letters testamentary, or at a minimum, a letters of administration that you can then present to the bank and handle the accounts. Where the times where I recommended a TOD or a POD was when we had, let's say, unmarried individuals, or where there was no other state law protection, and maybe you knew that the family did not agree with those two individuals as a couple. And so in that case, it was kind of belts and suspenders, where the will or trust was leaving something to that surviving partner, and we had the TODs or PODs, so that if the will and trust was challenged, then under contract law, we still had the protections under the TOD or POD. That was kind of the rare situation where we felt like we needed to exhaust all options to ensure that the family could not frustrate the estate plan. Beyond that, if it's a fairly straightforward situation, your will control, and the TOD, POD, and beneficiary designations can then be a backup. What you run into a situation with is somebody will deplete the estate of all assets by using the TOD and PODs, but now all states tend to have a clawback clause where you can pull those proceeds back into the estate to pay the administration cost. And for creditors, you can't use them to cut out creditors. They can also claw back. So again, knowing why you're using them, if it's just to get access to the funds more quickly, that would not be the top reason that I would give.
Well, one of the reasons too is that if I'm not mistaken, in North Carolina, if you pass without a will, then and you're married, then the spouse's family gets part of your estate.
Well, in North Carolina, like most states, a spouse is protected no matter what to an elective share. But beyond that, you would have to look at the individual states and intestacy clause to determine, and North Carolina now has really two factors: whether or not there are children and how many, and then also how long have the people been married. Because we used to see a lot of deathbed weddings to cut out the kids. And so again, North Carolina has tweaked their intestacy statute. But that goes back to the whole premise. It's a lot easier to get a will and try and head these things off proactively than to be dependent on the intestacy statute. Any other questions? I can't, and I apologize, can't see the chat for some reason. So if there are questions on there, happy to answer them if someone could read it out.
I have a question. I am single. Well, I divorced back in 2020, and I do own my home. And my ex and I, we have a 28-year-old. So I guess my question one would be, when is a good time to have my son, my 28-year-old, to have his documents in place? Because right now he has no heirs and is not married yet.
Yeah.
So I just don't want to go forward and assume that, if something were to happen to him, that I can automatically step in, or, or his father would make that final decision regarding his estate.
So I'm gonna answer this broad first. My recommendation is that anybody over the age of 18 have the basic documents in place. At a minimum, have a healthcare power of attorney and a durable general power of attorney. Even if you don't have a will, because you don't think you have any assets yet, but having those two documents, after I got called into a couple of very unfortunate, unforeseen situations, I started actually giving that away as a graduation gift to like friends and neighbors' children when they were 18, particularly if they were going off to the military or to school or moving away, is giving them those two documents and walking them through and explaining it. Because in the situations where I got called in, because 18-year-olds and I guess 20-year-olds are immortal, nothing's going to ever happen to them. If they were in a car accident or had a sudden illness, COVID was probably the biggest wake-up call that anyone ever got, where you never expected to be in that situation. Having those documents allows someone to step in temporarily and handle your financial affairs, handle your medical affairs. I've seen situations like with car accidents where maybe someone on your behalf either needed to defend a legal claim or to bring one on behalf of you while you were incapacitated, or permanently disabled. And so again, anybody over the age of 18 needs to have the documents. I thought you were going to actually ask me when should I name him in my documents. And so the second answer I was going to give is when you feel comfortable having your child make a decision for you. I've got two of my own and a third, and I'm not really sure I would let any of the three of them make those decisions yet. But at some point, I hope they're, thinking clear-headed. They're teenagers right now.
Thank you. I was actually put in a position because other relatives were not able, they knew that they wouldn't be able to make a decision like that. So my uncle decided that I should be the one.
Yep. And see, that's a great point, because having those conversations ahead of time are critical. Definitely, if you can do it before you're in that situation, it's a lot easier to talk about. I ended up in that same spot with my father-in-law because neither of his two sons felt comfortable making a decision. And so he asked me if I would mind being the one, and also the one, to handle things from a financial and legal standpoint. And I said yes. And so again, my husband still he's not comfortable making the decision. So I've named my sister, but we all understand why. And so I think that's a great point to show that, sometimes that is the best plan. And for anybody that thinks that this doesn't happen to all of us, I spent Saturday with my mother in the ER again, trying to talk my sister off the ledge, because she's always that one that in the middle of a crisis is like, we got to redo her documents. She needs to move, da, 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 da. And I'm like, not now. And so again, it's all of us will find ourselves in this situation at some point with a family member or a friend. And Kelly, if you can see the chat, if there are other questions out there, just let me know what those are.
There is one question, will okay, about the slides, will the slides be emailed after the seminar?
But I'm happy to.
Okay, thank you.
Sure. Are there anybody else have a question? I will tell you one thing to be very, very careful about is the titling and inadvertently creating a gifting situation, which then has tax implications for you, but more importantly, could render that individual ineligible for benefits. I saw too many times when families came to me and they'd already put names on deeds, or they'd already put names on bank accounts as joint owners, you know, to quote, help write checks. And that's all they were doing. But when we applied for Medicaid or VA benefits, they deemed it gifting and instituted a penalty period. You know, there were a few situations where they showed enough grace to allow me to reverse the transactions, but more often than not, they stood firm. And so, you know, if you're helping an individual or they're asking for your help and they want to start retitling things, just be very, very careful, because it can have unintended consequences, particularly if there is any kind of family dynamics and you don't want to be the target of a lot of accusations. So, you know, just tread very carefully, be very transparent, and, you know, be respectful of whatever estate plan is in place. You know, we did often see where the person who was the agent under the power of attorney would spend down or deplete all of the assets that were going to other family members, but somehow preserve the accounts that were going to be coming to them. You know, you really have got to be fair, or you're going to end up in a litigation situation. I will say this for anybody on the call: if you have not updated your documents since 2018, when the new Power of Attorney Act went into effect, I highly recommend that you consider doing that. Also for any other family members, because there were a lot of enhancements to the North Carolina Power of Attorney when the Uniform Power of Attorney Act was adopted by states, and it broadened significantly the abilities and the powers to do long-term care planning. And it also put in a tremendous amount of protections for the individual based on the agent's activities. And so where we used to see that as a area that was just ripe for fraud, they kind of closed that out. And then secondly, the ability to be able to do particularly a lot of special needs or supplemental needs trust work in order to preserve assets if somebody has to go on to benefits. It's really worthwhile, if you've got a document or your documents are older than 2018, to consider going in and refreshing them just for that reason. Does anybody have anything else? I'm happy to, I know this is the paralegal division. I'm happy to give you guys time back if you need to have time to cover paralegal specific matters. Also happy to follow up on any questions somebody might want to ask outside of the Zoom forum.
So I don't have a question, but I just have a comment on one of the slides that you had where you presented, where you showed the best way to bring these topics up. The one thing that I can never get my husband to really talk about it. So my church actually did an estate planning seminar,
Yep.
and it's some of the stuff they said when I was able to go and take that back to my husband. He's like, "Yeah, we need to do these right now." So if you have a church affiliation, there's um, that would be a good way to do it because the attorney that did the presentation is actually in lives in Raleigh, North Carolina. So if anybody, I can recommend it if anybody has any questions.
That is a great suggestion. I'm actually one of 3 in my church, and every year we do this presentation, just for those very reasons. You know, it's a safe place to have a conversation, and then if a member feels like they need to then follow up and schedule an appointment in order to have their documents either put in place or revised, they do that. And then they also broadened it, and made it actually kind of a Sunday school series. A lot of it focused on end of life, not just the legal and financial pieces. But that's a great suggestion.
Yeah, and he actually came. He's been to our church a couple of times, and he actually, if you were to make an appointment with him, he actually came to our house in the midst of COVID and met with us to talk about it. And he works evenings, so it's like he works around your schedule, which is really great.
That's awesome.
I do have a question. In case, I know in North Carolina for the wills, there is a requirement, to have 2 witnesses sign, the will as well as the notary. But I was wanting to find out how valid will the will be in cases where an individual, they draft up their own will and they sign it, but they don't have the notary, or they may have a notary, but they do not have 2 witnesses.
So there are statutes that govern that. And again, if it's a North Carolina will, I'm trying to give you a better example because some of the states have finally trued up. Like for a while, South Carolina and North Carolina were not in sync. And so I would run into a situation where I would have one, usually from New York and New Jersey, that had different witness and notary requirements be presented here. The person owned property in both states. North Carolina would accept it, but South Carolina would not. And so it really comes down to the statutes. Most often, particularly if there is real estate involved, you're going to have to meet the statutory requirements for a valid will. Now, there may be ways around it or ways to fix a situation. I happen to have that happen in my family. My father was an attorney. He had a daughter who was a trust and estate attorney, but his will from 40 plus years wasn't valid when he died unexpectedly, which was prior to the intestacy law changing, which meant my mom basically was cut out of a large portion of what should have been hers. And it came down to the witness and notary requirements. But what we were able to do is a settlement agreement amongst me, my mom, and my sister to make sure everything went to where it was supposed to be. My sister could disclaim, that would have been easy for her, but I could not. And so that's where, you know, if you have somebody in that situation where you know their will is already defective or is not going to meet statutory requirements, it is definitely worth the time to get it done now. The other thing that I used to run into, whether it was a client telling me that it was cheaper for them to do it online through LegalZoom or whatever forms they found, you know, versus hiring, you know, me or an attorney from my firm to just do it, we often saw that individuals who were not versed in this legal field would either make the wrong elections or not do everything correctly. So you ended up paying more during the administration of the estate to correct those errors than if you'd paid up front to get the right will in place. Again, not without the specifics around that individual's will, if you go out and look in the statutes and around a holographic will, you know, non-cooperative will, all of that, it will lay out exactly what you have to do and what avenues there are in order to overcome that if you're going to try and have it accepted for probate.
Thank you. And I'm
Yeah.
wondering with AI, I'm wondering if that will create any issues for the live wills, or so to speak, that they may have in the future, and verifying that the
Yeah.
person that they're looking at is actually the person that's actually speaking.
Yeah, so that's an interesting subject, you know, because I hear it more in the context of AI being used to like replace the attorney as a drafter, and you know that's a whole different ethical question. But we actually see more being focused on around electronic wills rather than the old printed hard copy witnessed notarized. And so I think you're going to see a lot of conversation around both of those pieces, AI and also the use of electronic documents going forward in a legal context. We've already got, you know, the virtual notary thing that came out of COVID. So it'll be interesting to see.
Thank you very much. I appreciate it.
Yes, sure thing. So, Lacera, I guess I will hand it back over to you.
And thank you, Stratford, for that presentation. If there are any closing remarks, Kelly, if you want to share anything. I know Lakeisha, our chair, she's not able to speak much right now. But I think we had a good turnout. Again, if there's anyone else that would like to mention anything, then I will go ahead and stop the recording. We should get a link distributed by the end of the week in case you missed it notice, so be on the lookout for that. And I do want to remind everyone we have another Power Hour scheduled for next Monday, so please tune into that if you can.
On behalf of the North Carolina Bar Association Paralegal Division, I just want to say thank you so much, Stratford, for giving us this invaluable information, which we all need. And let's go out there and share it with our family and friends. Again, thank you for this information, and have a great day.
You too, and thank you so much for the opportunity to be with you today.
All right.
Y'all have a great.
Thank you. Great information. Appreciate it.
Thank you, everyone.
Thank you.